So we're going to talk today about the employment law update. We'll touch on COVID at the end. If you can see the PowerPoint outline, I thought we'd go through a recent U.S. Supreme Court case that was based on the topic of sex or gender. We're going to talk a little bit about employee hate speech on social media and how that's been handled here recently. We'll talk about disability accommodations law and a few updates in that area. There's an interesting trade secrets restrictive covenants case that I think might be a little humorous. Todd, I'm giving you fair warning. You did excellently a couple months ago at pulling out an interesting fact to know and tell. So you may be back on the hook for that interesting point when we get to that on trade secrets. There's a limits on employee abusive conduct in the workplace case that I'd like to talk about, and then do what I can to talk about the latest on the COVID situation, particularly the Families First legislation and the rules. So that's kind of what I propose. All those in favor signify by, oh, I guess we don't vote here. This is not a democracy. So we will keep moving on. So as a starting premise, I usually like to say to anybody who will listen, and I know Mom is listening and she's a great audience, that it's a starting premise in any human resource matter that involves discrimination or any of the labor laws. There's likely to be both state and federal laws that apply to the matter. So we as employers, as human resources professional, need to remember to analyze all relevant laws. Certainly what we'll be talking a little bit about here today is Title VII, the federal law that deals with discrimination, but there's also a Wisconsin Fair Employment Act that we want to be mindful of as well. So that applies just generally speaking. So where were we a year ago? It's kind of fun to always look back. So it's hard to imagine maybe for some of us that we were in had many important things to deal with, like a trade war with China was kind of preeminent in the news just a year ago. I think COVID was nowhere to be found at that moment on anybody's radar screen. The other thing about a year ago, you baseball fans will remember that the Brewers dropped a one-game playoff to the Washington Nationals. They scored a 4-3. I think that was one of the few games that Josh Hader blew a lead in the 8th inning. So that's just a one-year look back and give us some perspective as to where we are now. So what I'd like to talk about now is the general topic of sex discrimination and what's happened in federal law over the last year. There was a case that the U.S. Supreme Court recently decided in June of this year. It's called the Bostic case, in consideration with two other cases. And basically the issue there, does an employer who fires an individual merely for being gay or transgender violate the Civil Rights Act of 1964 or Title VII? So nationwide, that was a big deal to have a court decide that. The law itself, we'll get to in just a moment. In this case, the facts were involved this. So Mr. Bostic worked for a public entity, worked for Georgia as a child welfare advocate. After a decade with the county, Mr. Bostic began participating in a gay recreational softball league. Soon after that, he was terminated. In a companion case, just to give you a flavor of some of the facts that went into this case, Donald Zarda, Mr. Zarda worked as a skydiving instructor at a place in New York, state of New York. After several seasons with the company, Mr. Zarda mentioned that he was gay, and days later he was fired. And then finally, the third companion case was that there was a person known as Amy Stevens who worked at a funeral home in Michigan. When she was first hired, she presented as a male, but then 2 years later, she changed genders and migrated to a male gender. And Ms. Stevens then wrote a letter to her employer explaining that she planned to live and work full-time as a woman. The funeral home then fired her, telling her this is not going to work out. So that was kind of the factual background of the three cases that presented. So for what it's worth, let me just offer that Title VII then makes it unlawful for an employer to refuse to hire or discharge any individual because of that long list of protected classes, as we say, because of things like race, color, religion, or sex, or national origin. In this particular companion cases, the majority holds that the term sex, which was the term used, rightly so, in the 1964 legislation, refers to the biological distinctions between male and female. It went on to some other language that it looked at because of, and what the term because of meant. For there to be a discrimination based on sex, it has to be because of sex. So I've got a slide here. My slide number 9 is probably a slide that only attorneys could love. And so if there are any attorneys in the audience, I'll ask you to read quickly, and because we're going to move on off the slide pretty quickly, but it goes into a little bit of the court's analysis. My slide number 10 then says the majority gave this example about considering an employer, just saying, with a policy of firing any woman it discovers to be a Yankee fan, and then carrying out the rule that the employer fires any employee who's a Yankee is a firing because of sex if the employer would also have tolerated the same allegiance in a male employee. Now, if you, like me, are feeling, man, this analysis, or jeepers, this analysis is getting pretty tortured, I would agree with you. The important bottom line decision to note is that federal law now acknowledges that discrimination because of sex includes because of gender or gender identity. And so that is now commonplace. Why does that matter to us as Wisconsin employers? Because we already have that rule established under the Wisconsin Fair Employment Act. Well, it matters sometimes because an employee who is subject or has the benefit of federal law now may also be eligible for, in certain instances, enhanced damages, punitive damages, for example. So an employee an employee to whom the laws apply now has a choice, if you will, between a federal forum and a state forum. And I usually like to say that and inform the audience that while Wisconsin law applies to an employer with just one employee or more, federal law applies to employers with 15 or more employees. So there's good reason to be aware of both of those laws. Next, quickly take a drink of coffee, and I would invite you to do the same. Employee hate speech on social media. It's an important topic. I think this slide interested me because of what was borne out. We've had a lot of really horrific images throughout the United States over the course of the last year or thereabouts on human interaction, to be mild about it. One interaction, of course, was those of us who saw that video in Central Park, where the person on her didn't have her dog on the leash, I think, initially, but then she did, and a black man challenged her in that regard, and she then went out and called the police. Now, she wasn't using social media, but let me talk more about how to think about hate speech if your employees are engaging in hate speech under your watch as an employer, how to start to think about that problem. My first bullet point up on that slide number 13 says that private sector employees do not have the same free speech rights as public sector employees. So we all have to be careful about how we use our terminology. And although we like to think broadly about the concept of I've got free speech rights, an employee might say, it's only partially true and not entirely true at all in a private sector setting. It's much more true in a public sector setting, and I've got a slide here that'll talk a little bit more about the public sector. So my second square bullet there talks about examples of social media posts that may warrant disciplinary actions or termination by the employer. Certainly any hate speech regarding a protected class, you know, based on race, disability, sex, gender identity now, may be grounds that warrant disciplinary actions or termination, especially if you have at-will employees, as many of us have. That's the standard basis for most private sector, at least, employment relationships in the state of Wisconsin, and indeed throughout the United States. Another example is speech that is severe enough to constitute a hostile work environment, either within the workplace itself, if somebody is posting statements out on social media that are threatening to other employees or to your clients or to your customer base, or giving the innuendo that harm may befall them if somebody does take certain steps, sort of watch out in kind of a foreshadowing or overbearing way. That may be speech that is severe enough to constitute hostile work environment that allows the employer to take action in certain circumstances. Threats to employee health and safety out on the internet or social media posts would certainly be another basis that likely may warrant disciplinary actions or termination. Finally, speech that damages the company's clients, customers, or community at large, and this is where I put that Amy, but I think the lady's name was Amy Cooper, who made the decision to call the police on the person who was asking her to tie up her dog according to park rules. You know, I was struck, maybe you were too, with the rapidness, the utter efficiency that her employer, I think it was Franklin Templeton, took to terminate her. I think it was within 24 hours, she was gone, and she was probably an at-will employee. Probably did not have any sort of due process rights, because of many private sector employees do not have due process rights to their position. So that is kind of a brief background about social media speech and how you can think about it if you are unfortunately posed with that kind of a problem in your role as an employer. I put a caveat down at the very bottom of that slide, number 13, and it says this: that the National Labor Relations Act gives a right for employees to communicate with each other about wages, hours, and conditions of employment. And that's kind of a big thing that private sector employees need to keep in mind as well. So there's a balancing act that's going on really between the hate type speech, but speech that also goes to wages, hours, and conditions of employment. That the employer needs to develop kind of a thick skin about. I've got another slide to talk about that topic in a more specific way here in the minutes that are ahead of us. Okay, so here's my slide on the public sector, brief slide. So if you work for a public sector employer, a government employer, you probably know that the notion of free speech does have a greater traction for you and your employees than the private sector. There are First Amendment rights that apply in that instance when the employee is speaking as a private citizen and not as in his or her capacity as an employee. When the employee is speaking on a matter of public concern, and when that interest in speaking outweighs the government employee's interest in efficiently fulfilling its public services. So maybe an example here might be when a public sector employee goes to a budget hearing, and unrelated to the budget for his or her particular department. Say that she's a custodian in the custodial department of a public sector employee. And the employee in this instance, is upset about how many, or how few resources are being devoted to, I don't know, social programming in this particular governmental budget. So she goes to the meeting and raises issues about why there should be an increase in budget for social services, just saying. She would be speaking most likely as a private citizen. She may be speaking on a matter of public concern. Pardon my cough. And then so if the government got its undies in a bundle in that point and said, you know, we're going to discipline the public employee for speaking out, that could be problematic in that instance if it just looks to be retaliatory. So that's how the free speech idea works itself out, generally speaking, how it may work into speech on the internet as well. So that's a basic distinction there. All righty. Disability Accommodations Law. As we know, there are two laws that apply to us as employers under disability law. And it's, again, the Americans with Disabilities Act, as it was amended about 10 years ago, 10 or 15 years ago, as well as the Wisconsin Fair Employment Act. Each of those laws apply to us as employers. It's always interesting to know, keep abreast of the cases and the decisions under each of those laws, because it affects how we, the employer, go about decision making with people who have disabilities and how far we, the employer, need to go to accommodate. So in this instance, I picked out a situation whereby the EEOC, the Equal Employment Opportunity Commission, which is kind of the federal policewoman, if you will, of discrimination laws throughout the United States, sued the Union Pacific Railroad, and they ultimately reached a settlement for $260,000, where the Union Pacific Railroad agreed to pay that amount in settlement. According to this lawsuit, the Union Pacific engaged in unlawful discrimination at the Ogilvie Transportation Center. Has anybody been there in downtown Chicago? If you're taking the train in from many places, I think that's where we all land. In this case, the employer refused to allow an employee who once had a brain tumor to return to work as a custodian, a position that the employer, Union Pacific, said was safety critical. And because it was safety critical, they perceived that the person who had the brain tumor was no longer fit or qualified to do his job. The EEOC in the suit contended that the employer failed to conduct, here's something that's important, an appropriate individualized assessment to determine whether the employee could safely perform the essential functions of the job. So in this case, the lesson, what happened is that the employer just acted too precipitously in considering whether that employee could come back and do the essential functions of the job. So the lesson for us as employers is always conduct an appropriate individualized assessment of a person with a disability rather than painting with a broad brush. You know, forget the preconceptions, the prejudgments, the biases that we may come to the table with in terms of our analysis, and look at the objectives of whether an individual can perform the job. My last line on that slide, number 17, of course, says to remember to review Wisconsin decisions as well. This is a federal case, but the concepts are rather similar. How are we doing? Is mom still on the line? Can you tell, Karen? Is my mom? She's not, she left. Okay. Is there anybody who I'm speaking to? Karen, I see your likeness there. There are some people. Okay. I'll keep going for who's ever left here. How am I doing? Okay.
You're doing great, Brian.
All righty. That's nice of you to say, Karen. That's just a likeness. That's not really you. You've got your cutout there just saying, it's kind of probably a smart speaker you got going saying, yeah, just tell Formella he's doing well. If Formella says, how am I doing? Respond, you're doing well, Brian. Okay, here we go. Thanks for the smart speaker support. So there's another case then that kind of goes another way in kind of the employer's favor on this disability analysis that I thought would be helpful. It was a case that was decided back in February. And it kind of has a local flavor to it because the employer was in Wausau. It's the Stelter versus Wisconsin Physician Insurance Corp case that was, as I said, decided in February. In this case, the employee, Stelter, sued her former employer, WPS, for discrimination, what she felt was retaliation in violation, she said, of the ADA. Now, in this case, Ms. Stelter alleged back pain that was aggravated by an injury at work. The employer states, however, that it terminated the employee for a pattern of absenteeism and deficiencies. So you've got kind of this perfect storm brewing where a person may have a disability and yet is absent routinely from the workplace, she says, because of that disability. I go through some of the history of Ms. Stelter. She was employed as a sales assistant in 2002, worked her way up the organizational structure. And interestingly, she injured her back while at work. WPS approved her request for time off, at least initially. She was then cleared to return to work with no restriction. She was good to go. And although she was placed on a PIP, a performance improvement plan, for substandard performance. Notwithstanding that improvement plan, her area manager, the person who supervised Ms. Stelter, recommended that she be terminated, among other reasons, for continuing to leave work for appointments without giving notice. And so in this case, the employer did apparently a sufficiently good job of documenting the very reasons why the employee with a back injury was going to be terminated. So here, for our purposes, it's good to know that the ADA claim is based on an employee who is disabled. So these are all obligations or proof elements for the employee. The employee is disabled, she's otherwise qualified to perform the essential functions of the job, and that the termination or the adverse job action was caused by the employer's animosity or a disdain or because of that disability. Those are the elements. Here, the court said that if that employee, if that individual is not qualified for her job for reasons related to the disability, the ADA does not act as a shelter. It's not a safe harbor from an adverse employment action, like termination, obviously, is an adverse employment action. There was this argument that the employee made that the absenteeism issue was just a pretext for her termination. That was really based on animosity due to her back injury over time. But enough time, the court had found that enough time had passed to have that not be the reason. And the court was pretty strong in coming down and saying that the ADA does not protect persons with unexplained absences. The fact, in most cases, attendance here is key for all of us to know. Attendance is a basic requirement of almost all jobs. So the Court of Appeals upheld that the termination was indeed due to the absenteeism, the business reason given by the employer, and not the reason that the employee suggested, that being the disability. So the other interesting thing here is that there's this interactive process that the ADA requires. And that means is that if an employee comes to us as an employer and says, I've got a disability, I may need to be accommodated. Usually, almost always, the employer needs to be respectful of that dialogue of back and forth. In this instance, the employee did not request an accommodation for her disability to claim, to really give standing to a claim under the ADA. So in this instance, so it's an interesting case that apparently Ms. Stelter didn't set the table well to make a claim under the ADA. She didn't go to the employer to ask for a reasonable accommodation. In my slide number 23, I ask us to be mindful as Wisconsin employers that Wisconsin law is, in my opinion, a tad more expansive and requires an employer to initially engage an employee regarding possible accommodations that may be necessary to allow that employee to adequately perform the essential functions of the job. no magic words may be necessary in Wisconsin. So to try to unpack that just a little bit, if even though in the Stelter case, Stelter apparently, Ms. Stelter did not go to the employer and say, I need to be absent due to my disability. What can we do to navigate that accommodation request? She didn't talk about that, apparently, according to the case. In Wisconsin, if we, the employer, catch wind that employee has a disability, it may well be in our interest to take the ball to the employee to discuss the whether there are accommodations that may help the employee who we have to determine whether she's otherwise qualified, whether there are reasonable accommodations. So I don't think the lesson is that for Wisconsin employers, we don't have the luxury of always just sitting back and waiting for an employee to say the magic words. Does that make sense? We may have to be a little bit more proactive depending on all of the circumstances. And circumstances do matter. So each case should be looked at differently. So that's my lowdown, I suggest, on matters relating to disabilities law update. Todd, here's where it gets a little bit fun from what you picked out the last time. This is a little bit more of a lighthearted look at a very difficult subject, and that's the subject of trade secrets and restrictive covenants in employment relationships. Why? And my goodness, we could spend we could spend 10 minutes on this topic alone. I'm being facetious. We could spend days on this topic, of course, as to how to write an enforceable restricted covenant agreement, what is working and not working, and what's allowable and not allowable in Wisconsin under Wisconsin law. Most law deal with restrictive covenants is state-based law. We know that Wisconsin has a 5-factor test to determine whether a restricted covenant in an employee contract is enforceable or not. None of that, however, is what we're really going to be speaking about here as such. Rather, it is the plight of a person known as, is it Anthony Lewandowski? My screen is a little bit obliterated by the slide, the Zoom side of my screen here, and if I were smart enough to know how to do that, I would change it. So I'll go to my hard copy here. Yeah, so it's looks like my slide number 25 then. Anthony Lewandowski, a real interesting guy, smart guy. He worked originally for Google's Waymo division, which apparently is its division that was working on automated cars and the automated self-driving car technology. He then left Google to go to Uber, and Uber worked for Uber's autonomous driving unit. And that's when a fair amount of stuff hit the fan. Google sued Uber and also sued Lewandowski under several theories, including a breach of his restrictive covenants and theft of trade secrets. So there was quite a bit of heavy litigation going on. And apparently what discovery in that litigation showed is that Mr. Lewandowski had indeed taken important proprietary information and trade secrets from the Waymo, his Waymo project, or his project on behalf of Waymo, to Uber. So there was this carrying and kind of walking away with, figuratively speaking or metaphorically speaking, caseloads and backpack loads of stuff, of confidential information. So I don't think he was that obvious about it, but at least in metaphorical sense, he took all this stuff with him to Uber. Now, it got so bad that in this instance, there was a criminal case that was filed against Mr. Lewandowski. Pardon my cough. So he was sentenced recently, and this was in August, to 18 months in prison, again, just recently here in 2020. As part of the trial settlement, from what I read, between Uber and Waymo, and that would be the civil settlement, not necessarily part of the criminal settlement, Uber agreed to transfer to Waymo 0.34 percent of 1% of Uber's equity. Todd, do you happen to recall what glorious sum was that amount, if you recall?
Oh man, I'm sorry, Brian. It slipped my memory.
No, that's okay. It was, I think it was 7 figures easily that you were able to determine. So those of you who want to grace us with what that math may be, go ahead. But the point being in this portion of the topic is that even when restrictive covenants in an employer agreement may be difficult to enforce on behalf of an employer, and there's a statute that applies. It's 103.465 is the statute that we use in Wisconsin to build our restrictive covenant agreements. There may be a significant remedies available to employers for theft of bona fide trade secrets under Wisconsin law, even without an enforceable restrictive covenant agreement. So in my opinion, as we have more proprietary information, more valuable information, I think trade secret law, federal and state trade secret law will be useful for employers' interests in maintaining their trade secrets. And now Mr. Lewandowski knows just how useful criminal law may be in that same setting. So that's a brief lowdown on the significance, at least one very serious case of trade secret theft. In this case, too, you should know that Uber tried to do what it could to really disavow itself of Lewandowski. I mean, obviously, Uber wanted all the know-how that he brought with him. Uber tried to make an argument that that they were innocent, that they had no idea that Mr. Lewandowski had this kind of knowledge, and certainly if he did, they would never use it. So they battled about that back and forth in court. At one point, Uber wrote a very interesting letter to Mr. Lewandowski that said essentially that thou shalt not use any of your prior knowledge here with our company. They I don't know if they did that at the front end of their employment relationship, which would have been a very good idea. They certainly did it in the main of their relationship. So to unpack that idea for Wisconsin employers, if we're taking on a key employee who's coming from another organization, there are things that we, the new employer, want to do to avoid our potential liability to a prior employee, to a prior employer, when we are hiring a former employee of that prior employer, to protect ourselves, the new employer, from accusations of theft of trade secrets or interference with contractual rights. That's a huge topic and probably deserving of its own topic point someday.
Brian?
Hi, Todd.
Hi, roughly $272 million.
Okay. Thank you. That's a remarkable sum to be at 0.34% or whatever it is. But thank you for that interesting figure, Todd. How did you get there? Did Karen give you that on the chat or what? Or is that your own work product, Todd?
No, I went on the Google,
Oh,
and it said their value, Uber's valued at basically 80 billion. So I took 0.34% of 80 billion on my Samsung calculator.
Sheer genius. Genius, Todd. Just sheer genius. I want everyone to know that.
Yeah, right.
We are being recorded, right? So this goes down into perpetuity. But thank you. It's good to know that you did your own math and that Karen didn't do it for you this time. No, I'm kidding. I'm being facetious. All right, so we are moving on to another topic. I hope I have another topic here left. Yeah, I think I got a couple of them. Limits on employee abusive conduct in the workplace. So if I were real slick, I probably would have juxtaposed this item E with item B, if my outline correct. My outline would hold. Yeah, hate speech. It's kind of a cousin concept, maybe, because abusive conduct is kind of a type of speech, if you will, in an oddball way of looking at how the law considers stuff. But there was an interesting case that came down within the last several months from the National Labor Relations Board. I shortened the case to just the General Motors LLC case, although it does have a longer listing if we were to try to look for it within the NLRB. In this case, the General Motors case before the National Labor Relations Board, there was a gentleman by the name of Charles Robinson who worked as a union committee representative. GM suspended him 3 times in 3 separate incidents in which he engaged in arguably profane or racially offensive conduct towards the management or at a bargaining committee. At one point, Mr. Robinson yelled at a manager that he did not give an expletive deleted about your cross training, and that we're not going to do any expletive deleted cross training if you're going to be acting that way. And so there was just a lot of back and forth in this environment. And so the employer suspended Robinson for 3 days for that kind of conduct. Now remember, this is a union setting. Union settings, of course, will have their own negotiated rules for how one terminates an employee or disciplines an employee. Robinson, it says here in this slide, was later suspended for 30 days for other similar activities. He then brought an action before the NLRB stating that his rights under the National Labor Relations Law were violated. Now, although this is a union-related case, and many of us may no longer be in union-related settings, the principle is still valid. And the principle that I want to get at is that all employees, all private sector employees, whether they are in a union or not in a union, have a right to engage in what's called concerted activity for mutual aid and protection. That's a federal given right under the NLR, National Labor Relations Act. Public sector employees have that same right, at least state-related public sector employees have that same right under state law, this right to combine, to act in concert with each other. And so you get another, arm wrestling match between, employee interests who may claim my bad speech was just a function of, was just a part of my wanting to engage in, or my actually engaging in concerted rights, joint rights on wages, hours, and conditions of employment. And there's traction to that argument that employer needs to have a thick skin to that workplace related speech and conduct here. But this case stands for the proposition that abusive speech doesn't go on endlessly, that there is a limit to how abusive any employee can be in the workplace, even in a concerted activity setting, whether it's union or non-union. So let's kind of work those facts just a little bit. Pardon me. So this slide number 30, does it say the NLRB now relaxes the standard for determining whether employees have been lawfully disciplined or discharged after making abusive or offensive statements in the course of activity that's otherwise protected under the National Labor Relations Act. And again, what is that protected activity? It's the activity to engage in mutual and concerted activity for mutual aid or protection relative to wages, hours, and conditions of employment. That's sacred ground under the National Labor Relations Act. Let's see. So the NLRB said that some employee activity that seems over the top is protected. I guess that's the point that I just made a moment ago, as part of the right for employees to engage in concerted activity for mutual aid or protection, whether or not there is a union setting. So that just kind of repeats what I offered up a minute or two ago. Now, under the prior standard that was used to look at Mr. Robinson's speech, some believe that there was too much leniency. You all know that the National Labor Relations Board changes personnel. The 5-member board changes routinely when there's different administrations in office. So unfortunately, the interpretation of the National Labor Relations Act will necessarily evolve over time or devolve. It'll go back to prior holdings from before. So it's just very cyclical. But at the point that the cycle that we are in now, at least, now profanity-laced tirades and other abusive conduct in the workplace may well lose the protection of this right to engage in concerted activity for mutual aid or protection. Us employees who engage in obscene, racist, and sexually harassing speech may now be subject to discipline, including termination without reinstatement, in situations where they may have had a right to be reinstated before. So it's easy enough to unpack what that means without losing sight of the principles. So you don't, as employers, we may not need to take as much guff as we took before, but still understanding that we shouldn't be too knee-jerk in our reactions to tough speech from an employee due to that right to engage in concerted activity. So let's see what I put down as my lesson for employers. Yeah, I do say that the NLRA applies to most of us as Wisconsin employers, even when a union is not present. Yeah, we talked about the basic right to engage in concerted activity. Now there is a reduction in the amount of outrageous behavior that an employer must tolerate as part of the employee's otherwise right to engage in that protected activity. Here's the test. Was the employee's protected activity a motivating factor in the disciplinary action? Because it's the protected activity that is sacred turf under the law. If yes, then you still have to ask this next question. Would the employer have taken the same action, that is, a suspension or a termination, in the absence of that protected activity by showing consistent discipline of other employees who engage in similar abusive or offensive conduct? That's what the NLRB, the National Labor Relations Board, is looking for employers to kind of document through. So again, you've heard me and others like me, discuss the point of being consistent in our documentation, being objective in our documentation when there are events that need to be disciplined. It's not easy disciplining, I suspect, in most instances, but that consistency of objectivity can help us in instances where somebody goes over the top. Oh, here's, so that's that concept. So now I'm ready to move on to another concept, if you all are, except I'll grab a water drink here, excuse me. So what is the latest on the COVID situation and things like the Family First legislation? We know that the state has come out with the governor's masking order, as well as I think it came through the HSS department, the order with respect to social gatherings. We now have a restriction on social gatherings. Again, that's the emergency order number 3 that came out of the Department of Health Services. So the big case from, I think it was May, was the Wisconsin legislature versus Palm. It was our state Supreme Court ruling that the Safer at Home order had to go, and it was unenforceable under circumstances, and that was effective immediately. You all remember that kind of watershed moment from May, I think it was, of this year. So then, I don't know that there's a huge lesson for employers, but let me try to recite what I put here in this slide. Yeah, we know that the Palm decision does not directly impact any local orders. Here in Portage County, I think we have one local order, but I do believe that local order is written in kind of a guidance sense and not in a true order, so that there's penalties. I don't mean to diminish the importance or the value of that local order as much as to say, from a legal perspective, it doesn't have the force and effect of law as such, although there may be indeed valuable guidance within it. There's still statutory authority that gives local healthcare officials the ability to issue orders. Employers need to ensure that a return to work plan complies with any existing applicable local health orders and any new standards that are issued, such as Governor Evers' Emergency Order number 1, which was just extended, I think, a couple of weeks ago to mid-November, if I recall correctly. And order number 1 is the masking order. A lot to unpack there, of course. My next slide is slide number 37. We have, some real major legislation, but it's going to sunset as of December 31. Is the Family First Coronavirus Response Act, which goes through the end of December. It applies to employers with fewer than 500 employees. These are things that we already know. It requires employers to offer paid sick leave and then a bucket of benefits known as emergency family medical leave who are unable to work due to the pandemic. You know about the poster that exists already out there that no doubt all of you as employers have already posted. There's another site to it. I don't think it's hyperlinked, I say, unfortunately, but that is the site to find that poster that would speak relatively efficiently to the rights that exist, at least through the end of this month. I haven't heard anything, neither of you. I don't suppose that there's any real movement between Congress and the executive branch at this moment to extend that law, although there is some day on, day off talk about extending it. Yeah, we know a little bit about, you're already aware about the federal, about the payroll tax credit that you as employers, that we as employers have if a person is getting paid leave benefits under the FFCRA. That's all kind of old news in a sense. Then on August 5 of this year, there was a federal court in New York that struck down portions of the Department of Labor's, the U.S. Department of Labor's final rule. If you're like me, you've been exercising your path, your electronic path to the wage and hours division site that's set up for all things about the Families First law. And you know that the division of wage and hours has put out a lot of frequently asked questions on that have been in many instances quite helpful. Then along comes the federal court in New York on August 5th to undo several of the benefits and undoing several of the understood frequently asked questions. One of the questions, or one of the issues, is that the DOL's definition of a healthcare provider was found to be unlawful according to the federal court. So the upshot is that now the Families First rules have been, at least in part, revised by the Department of Labor by a publication on September 16, 2016. And I've got the 60-page document right here. We're going to go through it page by page. No, we're not, Karen. That was just a joke. We're not going to go through this page by page. But this September 16th document does modify in some respects or clarifies in other respects those frequently asked question guidance that the Department of Labor has given. So my recommendation to us as employers is that there is now again, a somewhat expanded definition of what a health care provider is under the law. That's helpful to know because there's an exception under the leave, the emergency leave portion of the law for health care providers to employees who are deemed to be healthcare providers. So to try to be succinct as to what I'm saying here, the new September guidance by the Department of Labor attempts to overcome the limitations that were shown or pronounced by the New York Federal District Court on August 5. So now what do we do? Well, and it would be my opinion that if we have issues that relate to the work availability prong of the Families First legislation, or certainly about the definition of a healthcare provider for those of you employers that may be thinking about whether you need to provide the Family First benefits, look at the new guidance that's issued by the Department of Labor in that September 16th missive. That was, let me find exactly how many pages it is, so you know what it's 52 pages. So I think it is necessary to not just stop at those frequently asked questions anymore. We now have to go to this guidance. The problem with the guidance from September is that it is not written in a frequently asked question format. It's in a narrative format. And so our reading of that will take necessarily pages and pages to get to our the bottom line from the Department of Labor's perspective, at least with respect to the Families First Coronavirus Relief Act. So please keep in mind that September 16, 2020 publication by the Department of Labor. So then what? So that's a quick overview of what I am suggesting for all of us. I've got a conclusion slide here that you can read as effectively as I can. So point number one, consider all laws that may apply both state and federal, please. Number two kind of reiterates that there are distinctions between state and federal law that we as Wisconsin employers need to be mindful first. We didn't really talk about the safety first pandemic trend, that state and federal guidance is that we need to maintain a safe workplace. And so some of the rules of the ADA and requesting testing are kind of bowing to this need to have a safe workplace in the first instance. Be aware of changing trends at the NLRB and the EEOC. That's what we've been trying to do here a little bit in a simple way. Your business judgment, this is point number 5, is really important to keep in mind. Even though there's just a myriad and a plethora, I think is the right word, a whole gob of laws that apply to the workplace, as we know. If you're able to exercise your business judgment in a systematic, objective way and think about what is good for business objectively, and then sprinkle the laws in there, I think it's not quite as daunting as just thinking I've got this influx, this dump truck load of laws. So your point being, the phrase business judgment does still matter in the law, whether you're a public sector or private sector employee. And I think by remembering that touchstone, it helps to guide any employer through the kind of the maze of employment and labor laws that exist out there. But we don't need to see that. Okay, that's the last slide. So that's what I've got for everybody for the good of the morning. Karen, I know you're monitoring whether there are any questions. I apologize, I don't see that here on my screen, but I'll be quiet for now.
Brian, could you flip back to your contact information in case somebody has to jump off the call?
Oh, yeah, that's
so people have your email.
Well,
they
there
can
it is.
Cover up your picture, but the email address and phone number are good to have.
Yeah,
so
yeah, you can Photoshop that. Yeah, but there it is. Okay, thanks, Todd.
There's a mustache on mine, but anyway, back to you, Karen.
You too. Just go back and forth. I got a good picture of that too, Brian.
Okay. Yeah, and I think, okay, very good. So I don't know if you've got any questions there or not, but it's been my pleasure being with you for this time period. Stay the course, exercise your business judgment. And again, Karen and Todd, thank you for allowing me to appear this morning.
And thank you, Brian, again for being here this morning and for your sponsorship. We want to thank everyone for joining us. Mark your calendars for our November exchange, which will be on the 11th, and it'll be sponsored by Red Shoes, communication, marketing, and PR firm. Kathy is on the call from Red Shoes this morning. So Kathy, we're excited. Yes, we see your mug. I love it. Todd, is there anything you'd like to add?
No, I want to thank Brian. I know Brian and I have a lot of fun teasing each other, but you certainly make a tough topic pleasurable to go through things for all your examples and everything that you do as a board member and that Anderson and Brian does for us and everybody else in the community. So thanks again, Brian.
Thank you.
Thanks again, Brian. Everybody have a great day.